Good afternoon and welcome to our Family Voice Zoom session this afternoon. I'm Andrew McColl, the Queensland Director of Family Voice, and it's my pleasure to welcome to our Family Voice Zoom today Henry Pike. Henry Pike grew up in an Air Force family and he's lived in many cities, both in Australia and overseas. He built a career as a property industry advocate across a range of Australia's largest industries. Henry's been the LNP MP for Bowman in East Brisbane since 2022. He's married to Kate and they have two children. He likes to say he believes in freedom and Australian values. Good afternoon, Henry.
G'day, Andrew. Thanks for having me on.
Pleasure. So I just wanted to run by you a quote from Noah Webster, who was an American and a fairly well-known American. He lived from 1758 to 1843, and he claimed that the moral principles and precepts contained in the scriptures ought to form the basis of all our civil constitutions and laws. All the miseries and evils which men suffer from vice, crime, ambition, injustice, oppression, slavery, and war proceed from their despising and neglecting the precepts contained in the Bible. Do you agree with Noah Webster?
I think it's an excellent quote. I think that he certainly lived in a time in the United States when they were struggling with all these sort of concepts. What is government? How do we deal with the issue of slavery? How do we deal with creating a new constitution for our new country? And I think he's absolutely right that if you start building up the framework from those first principles of what's in the scripture, you can't come up with a better starting point, really. And I think he's quite right in what he points out in terms of where we see society go backwards is where we really depart from that. And I think it's a good principle. He'd obviously put that forward in the 19th century, but if it's something that I think it's something that's still very relevant today and should be thought about by our legislators. Are we getting too far away from those first principles? And how do we ensure that whatever we're doing to layer on new legislation or new regulations is actually how are we getting away too far from where we should be? I think it's a fantastic quote.
Great. So you've been talking, Henry, about Labor's Human Rights Act, and what is it there that's in that legislation that is looming over us?
Absolutely. So we've got, I've been the Deputy Chair of the Parliament's Human Rights Committee for probably about the last 10 months or so. And I was thrown in the deep end because we've had an inquiry into Australia's human rights framework. And what I've soon discovered when I took on this role is that the Labor members of the committee, as well as Senator Lydia Thorpe, as well as Kylie Tink, the independent member for North Sydney, were very much pushing the idea of introducing a Human Rights Act into Australia. And that's where that's what the committee has recommended, and the government's got till the end of the year to respond to it. But we know that the government is very much in favour of this move. Now, a Human Rights Act isn't something that's a new concept in Australia. Back when our founding fathers sort of sat down and drafted a constitution, they looked at the American model and they looked at the Bill of Rights that America had, and they decided to reject that concept and to say that the rights that we enjoy as Australians and their rights that we've inherited through our traditions, going all the way back to, biblical times, and the concept that, we're all equal and that we're all made in the image of God. These are all, the basic fundamentals of human rights, if you boil it all back. What they rejected it because they thought that the best protectors of those human rights isn't through some sort of super bill or super act of the Parliament. But what they were of the view that it's actually our elected officials that are best placed to try to determine the balancing act between our different human rights. So essentially what Labor is proposing isn't something new. It's something that's been rejected very early on in our government. Had been proposed about 10 different times in the course of Australian history. It was floated by the Hawke government at one point. We've had different independent attempts at creating some sort of overarching Human Rights Act. But what they're proposing is something that's quite different. this isn't something that is going to reflect the Universal Declaration of Human Rights that we've got, that is sort of widely accepted as something that's the international norm of human rights. What they're proposing in this draft Human Rights Act, and it's something that they've included within that committee report. So if anyone wants to look at it, it's appended to the back of that report. They've very much gone down an activist angle with this. This isn't, it sounds great, the Human Rights Act. I don't think anyone would, think that that's a terrible thing. But when you read the detail, you suddenly realize that it very deliberately undermines the right of freedom of religion, the freedom of speech, all these sort of freedoms that the left of politics doesn't particularly like that much. They're trying to create a Human Rights Act that recalibrates the way we think about these things to put the pendulum back in their favor. And we've seen, unfortunately, in the United Kingdom, where they have a Human Rights Act that reflects the human rights obligations that they had under the European Charter, we've seen some really strange outcomes. That means that legislation and actions of the UK government have been heavily restricted because of the decision of judges. And this is the other point that I've been trying to make around this, that what their proposed act is actually saying is that it won't be the role of the Parliament anymore to determine what the balance of our rights should be. But a lot of the decisions will have to be made by the judiciary. And I can't think of anything worse than having a situation where an unelected and unaccountable judiciary is making assessments of our laws as to whether they meet certain conditions that are within this act that's been drafted by some of the more left-wing members of our Parliament, but also a lot of activists outside of the Parliament have had a role in drafting this as well. So it's quite concerning, and we could go further into the detail of that, but that's what we're facing at the moment.
Okay, so it's 2024, of course, and it's 123 years since Federation. We have 7 state and federal governments. Why does the Labor Party believe now, after all these years, that we need this massive document to be foisted upon us?
It's a good question. I think that for some on the left of politics, they've had this vision for quite a while. It's really stemmed from the Australian Human Rights Commission, and I don't know if your members have been following their activism recently, but they have been quite missing in action in terms of the recent rise in anti-Semitism that we've been witnessing. And they've got a lot of people who are working for them and with them who are, very much, I would describe them as left-wing activists. The Human Rights Commission has been championing the idea of a Human Rights Act for quite a while. Really, they see it as an opportunity to have some sort of, I call it a quasi-constitutional bit of legislation, because every bit of law that the Parliament would then pass would have to be measured up to this new Human Rights Act. And a lot of the judges would be called on quite a bit to measure up new legislation against what our previous Human Rights Act legislation would require of new acts. So you'd see a lot of legislation sort of ruled out. I think that what they're really trying to do is do a power grab. They're trying to put something in as a Trojan horse that will give them a lot more leverage and a lot more power than what they will be able to receive through the ballot box. And I think it's no surprise that you're seeing a lot of the people who were, activists on the recent referendum, strongly in favour of the Yes campaign, are now, have found this as a new cause that they're championing, because they see it as a way that they can get the policy outcomes that they want, whether it's to try to go after faith-based institutions, whether it's to try to silence the freedom of speech of certain individuals, whether it's to try to force environmental outcomes, whether it's to try to ensure that we don't have programs like the cashless debit card, which they've been opposed to. There's a whole range of different policy things that people are trying to achieve through this, but they see it as a way that they can get the outcome that they want without having to try to win the power of government, which is, of course, very difficult to do.
Okay, so you've written quite recently, Henry, that the government's proposed bill selectively and deliberately devalues internationally recognised protections for the freedom of thought and conscience and religion and belief. How does it do this?
Well, all those rights are articulated at an international level, quite detailed in the way that they go about it. And I don't pretend to be a human rights lawyer. I have to deal with them quite a bit on this committee, but they're very specific and they're very deeply thought out about how each of those protections or each of those human rights are balanced and protected, which of those human rights can be diminished, under what circumstances can they be diminished. And there's a very long history of this being finely calibrated in international agreements. The problem with what they've done is that they've essentially selectively devalued some of the key elements of it. One of the I'll just bring up my notes here because I'll outline one of the key problems with it is that they've got what they've really done is they've got in terms of religious education. So if you think about one of the key aspects of the international human rights agreements is that there's protection for parents to be able to select which how their children are educated, and protecting the right of parents to choose to have to provide their children with an education that provides a religious context to it that reflects their own faith. That element, for instance, has been removed. So that was
Right.
deemed to be a fully you couldn't under any circumstances impinge the parent's right to that, the parent's ability to have that right.
Yeah.
Under what is being proposed, that's completely gone. That's not considered as part of a freedom of religion. And of course, for a lot of people like me who choose, their children's schooling based on, on a range of factors, but a major factor being whether the education matches up to my, my values and my wife's values, and we want to ensure they get the religious instruction that we want. Removing that, I see it as really, particularly when you consider it next to all the other aspects of what the government's been doing in relation to DGR status for school building funds, in relation to watering down the exemptions that schools have to be able to employ people that share their values. It really starts to paint a picture as a government that's quite hostile to faith organizations and to people of faith. So that's one aspect of it, but there's multiple points there. If you get the human rights lawyers to look in through all the different aspects of this legislation, they're ringing the alarm bells because they're saying this doesn't match up. And one of the other classic ones is that there's a list of rights that can only be impeded upon when absolutely necessary. But under what is being proposed under the Act, it's not what's necessary, but it's what's reasonable. So you consider, a government may take an action. Well, look at the recent pandemic. They may take an action that they may be restricted from only if it's absolutely. They may take it if it's absolutely necessary for them to take it, not if it's reasonable for them to take it. There's a huge, difference in the evidence that'd be required to justify that. So it's very selective in what they've done. And, I think that they're hoping that most people will just sort of ignore that and think that it all sounds very nice and neat and good. But when you start to consider what a government might do in future, a government may say that, it's not, it's reasonable for us to take certain restrictions on religious schools. Whereas what we want them to say is, well, you can't do that unless it's absolutely necessary to do it. So when you dive into the detail of the law, it becomes quite concerning that they're wanting to go down this path. And they don't provide a lot of justification for it. It's just weird omissions. And I think it's quite nefarious what they're really trying to do here.
Well, it does sound, just from what you've been saying there, Henry, when you contrast the terms absolutely necessary and reasonable, well, reasonable on whose basis? Who said it's reasonable? And I mean, we would look at, I mean, like you, I'm also a parent, and in my context, a grandparent. We've got to think about what we think is necessary for education. But then if someone says, well, yeah, but you've got to be reasonable about that, there's going to be some controversy about that straight away. I mean, clearly, when you're looking at, say, schools, yes, there are some things that schools need to have, like easy access and fire escapes and fire hoses and all of those things that we would consider in a public building. That's necessary to have those things. But when you contrast that with the word reasonable, well, then as you say, you've downgraded that significantly to, you can have 50 people saying this and 50 people saying something else. So clearly that's going to be very controversial.
Yes, absolutely. And the other aspect of it is a lot of this will be left up to judges to determine. You're adding, a lot of this human rights stuff is just conflicting rights. How do we balance it? How do we say that someone can't be discriminated against versus someone's right to free speech? That's a balancing decision that needs to be made by someone at some point. And to me, my view is, I might be a bit biased because I'm a parliamentarian, but my sense is that the best people to make these decisions are those who are elected by the people to make those sort of decisions.
Yeah.
It's not, if you're putting all these decisions onto the judiciary, firstly, I think it's unfair on them because they're not, a lot of these are really just, policy calls that aren't really what they should be doing. They should be in sort of interpreting the law, but not, necessarily making harsh policy calls as to this is reasonable, this isn't. But also you're going to open them up to politically contentious debates. And we've seen that in, the United States, where we've got a heavily politicized judiciary that becomes, they've effectively become politicians in themselves. A lot of them are elected. They have, an election basis, whereas we don't. So you'll end up with a lot of judges who are making quite very important calls. And the people have no ability to hold them to account over that. If people don't like where I'm making the call on that balancing act, well, they don't have to vote for me next time. But with a judge, they're there till they reach the mandatory retirement age. So it's, I think we're moving into dangerous territory there. And I think the more that we actually have the debate at the political level, the closer it will be to getting a fairer decision. And you'll also open it up to debate. I'll say one thing, a Labor MP will say something else, an independent may say something else, and we're having the debate publicly, and people can make their own mind up. But if it's happening at the judicial level, it's it's something that we're having well above what most people are able to influence.
So do you think that our laws provide sufficient protection now?
On freedom of religion, I don't think they do. I think that, that's one area in Australian law where we probably do need we do need more protections. And I know the previous Liberal and National government did attempt to do that and didn't have the desired effect. I think that we certainly, a lot of the human rights that we have in this country are just sort of accepted norms. They're not necessarily things that are baked into our legislation. But if we start to see things creep away, and I'm thinking of, examples like Israel Folau, where someone can't express an opinion without losing their job and being made essentially, unemployable by a whole industry. I think that's a really terrible outcome in Australia, and I think we should have more protections to ensure that those sort of things don't occur.
Yep.
As to what that sort of legislation might look like, I'm I'm not going to commit today as to what we need to necessarily be doing, and that's obviously a big task that the next that we need to develop to heighten those protections. But I just think we do need more protections. But we definitely, I don't want to see some sort of super human rights act, which is trying to pretend as if it's the solution to these problems, but is actually undermining what we've already got, which already, isn't a lot, to be honest.
So would this mean that there be other bodies like the WHO and the UN that could actually dictate what our rights then really are?
Yes, I mean, it would be subject to us adopting. Already, we are treaty bound to protect certain rights amongst people who are within our jurisdiction, but it's not baked into our legislation. So there's already, we already have signed up. I think it's about 7 or 8 human rights treaties that we're signed up to, and we're obliged to defend. And what this act is framing itself is as an opportunity to put all those into legislation. Now, the problem is that they're, as I've mentioned, they're really they're twisting everything on the way through in terms of the translation. But I think that what we've got, to understand is that it's not necessarily, they could make decisions at an international level, whether it's WHO, whether it's the UN General Assembly, whether it's whatever other international forum that's going to occur. They could make a decision that we could add a whole heap of other subjective rights, and that a future Australian government may agree to, and then that would probably result in a change to our Human Rights Act to reflect whatever rights they're bringing in. For instance, in this new act, or in this proposed new act, they're looking at creating a right to clean environment, or right to housing, a right to social security. These are all very subjective. What is another one is the right to culture. What does that mean? How's a judge supposed to interpret whether an Australian citizen's having the right to culture? But when we get into, you can only imagine what a right to a clean environment may mean for some of our mining projects and, whatever else. My fear is that if we do go down this path and we end up in a situation where we're expecting to legislate everything that comes down on high from international bodies, we could end up really in quite a strange situation where we're starting to try to, fix in strange, trendy things that they're doing internationally that we really don't want to have a part of. So I'm concerned that we lose our sovereignty to some extent. Of course, all this would require, to go through a parliament and have it voted on. But once you've opened the door to it, I think that really we're, if we want to have a clean environment, for instance, well, let's move legislation to say these are the policies we're going to implement to have a clean environment. Let's not try to create a bit of a bypass here to enable them to, get all this stuff through without proper scrutiny.
Yes, well, I can understand that this discussion about culture. I mean, well, whose culture are we going to have, and on what basis are we going to have it? And if I'm in a public place and I decide that I don't like the culture that's being expressed by people around me using their free speech, well, I could protest about that and say, well, that's people over there, they don't share my culture, so I don't really like that. Now, that to me does sound very tricky and very messy.
Yes. Well, anything I think that just opens up the opportunity for more litigation around these sort of things, I think is just unhelpful. Like why are we creating these sort of avenues? I mean, to me, if someone wants to have more culture, if someone wants to have more social security, if someone wants better housing, that's something that they can pursue from a political level. Put forward a policy, put forward, go on a protest, wear a shirt, whatever you want to do, pursue that through our current structures. I don't really understand legislating very subjective things as well. Like how is a judge supposed to interpret what a clean environment is? Really, it should be the elected government that makes a call as to, okay, here's the level of social security that we're happy with. Here's what we're doing to support culture in Australia. Here's the baseline for housing in Australia, and I don't want to end up in a situation where a government's delivering a budget and saying, here's our increase to Commonwealth rental assistance, and then a court saying, well, that's not high enough because that doesn't meet our international obligations that we've been told to do around the international requirement that everyone has to have a house, etc. So it just becomes a lawyer's picnic. And having met a lot of human rights lawyers over the course of this inquiry, I don't think that's a good thing to unleash in Australia.
Yeah, well, you mentioned in something recently, Henry, that this act would insert abstract and vague concepts into our law that require judicial interpretation, like a right to culture and a right to a clean environment. Now, as soon as we go down the abstract and vague line in law, that's going to become almost terrifying. And not only that, it sounds very messy because that could mean different things to different people, and they're being interpreted that way as well.
Absolutely. And when you think about it, from an international perspective, imagine how widely different that will be interpreted. I'm sure a clean environment in China is a very different concept to a clean environment, in Western New South Wales. I think that there's, a good, it's just crazy to be undertaking these sort of subjective things. But I was most concerned, obviously, it's been very topical at the moment around immigration policy and concerns around some of the criminals who were recently released or, out of indefinite detention. And looking at the UK example, a lot of the court action that's undertaken through their Human Rights Act is in relation to keeping people in Australia keeping people in the United Kingdom when they've had criminal convictions. So there's a long list of cases in the UK, but we have sort of weird things like there was one Colombian. I'm just looking at my notes now if I can find his name. Bolivian national who was caught shoplifting. He was on a student visa. He was to be sent home, but the court determined that because he had a pet cat, he had a private life in the United Kingdom, and therefore to expel him from the nation would have resulted in a breach of his right to a private life. There was another one who was a part of a five-a-side football team, and therefore he could demonstrate that he had a private life in the United Kingdom that he couldn't be detached from. So he can imagine the sort of bizarre interpretations of this law that could be developed by judges. And particularly if you get a few activist judges on the bench who are, keen to use this to, pursue their agenda, and their agenda they may be big climate change activists who want to, destroy coal mining projects. There may be people who are hostile to religious schools who may want to pursue, that angle and make some strange interpretations of human rights on that front. So it's a recipe for a big public policy mess. And I think that governments of all persuasions have been wise to just let them to not pursue this, because I think they realize it's a bit of a Pandora's box. And once you open it, it'll be a very brave government indeed who decides that they're going to repeal the Human Rights Act. We saw the previous Tory government in the United Kingdom decide that they were going to repeal the Human Rights Act. And we saw what happened to them at the ballot box last week, but it was not pretty, and they abandoned that policy very early on. So, it's going to be, once you go down this path, it's a bit like the voice to Parliament. Once you go down this path, it's very hard to undo it. And so you want to be very certain that it's the right thing to do before you pursue it.
So this whole agenda kind of reminds me of President Reagan's warning when he said, when someone tells you I'm from the government and I'm here to help, look out. Am I right?
Oh, absolutely. It's a good line. I've got another line that I like from Harry Gibbs that I'll try to find quickly. It's Harry Gibbs was the former Chief Justice of Australia.
Yep.
I've got a bit of a connection to him in that his brother was a former member for Bowman as well, and is a great Queenslander. But he said, if society is tolerant and rational, it does not need a Bill of Rights. If it is not, no Bill of Rights will preserve it. And I think that's so true. And you look at so many different countries have hailed these great human rights acts or charters that they've had. You think of, the Soviet Union apparently had one of the greatest human rights charters of all time. If it doesn't, it's all right to say all these things. It's a question of what it actually means on the ground and what it means to your average citizen. Yes. And I really think that a lot of these international human rights agreements are really an attempt to reflect for countries that didn't have that sort of tradition, to really reflect that Judeo-Christian, English small government tradition of, individual freedoms and, the freedom of expression and the freedom of religion, the tolerance that had been sort of developed over the centuries. Yes. But for a lot of the countries, they didn't have that post-war. They didn't have that sort of tradition that they could lean back on. So they tried to develop these international agreements where they could just take it off the shelf and go, well, this is how I can ensure that we have good human rights moving forward in whatever new country has been developed, or whatever country wants to pursue that. But for us as Australians, we've already had that. We've got a strong tradition. I think we have a good record of human rights in Australia. Yes, it needs tinkering and needs maintenance, and it's good for us to have the debates around human rights and where we should draw the line. But the idea that we should be leaning on the international examples is something that, that really the international examples are attempting to reflect what we have here. We've flipped it around where we feel that we need to take something from the rest of the world and to demonstrate how virtuous we are. I just find it bizarre.
Yes. So if voters think about these things that you've been referring to, Henry, and they say, well, this sounds pretty awful. Well, what should they do about it?
Well, I'm encouraging members of the community to fill out a petition that I've got on my website. And we're using that to sort of demonstrate to MPs that, hey, we've got 100 people from your electorate who are concerned about this Human Rights Act. And really, I'm hoping to apply as much pressure as I can on Labor's backbench to say, are you sure you really want to pursue this? Because there are a lot of Labor luminaries over the years who've opposed this, including Bob Carr, including Robert McClellan, the former Attorney General. I'm hoping that it's not too late to get the government to rethink this. That said, we may have a federal election shortly, so who knows what the government will be after that point. But it's, I'm encouraging people to fill out that petition, but also to write to their MPs and senators and say, hey, I don't like the sound of what this is, and don't wave it through. Give it a serious, good look, and determine whether this is what it says it is, or whether this is some sort of Trojan horse for lawyers and activists to get the outcomes that they want. So
what's that website, Henry, that you're referring to there that they can go to?
It's let me get the URL right. I think it's henrypike.com.au/human rights. I think is the right address. And let me just check that while I'm talking to you. Yeah, Human Rights Act is the right one. So it's henrypike.com.au/human rights act.
Excellent.
But if you search my website, you'll find it. And it's slowly growing, but it's more about an education piece at this point. And that's why I've really appreciated the opportunity to come on today, Andrew, because I want the more people who know about this, the more opportunity we have to ensure we get a good outcome. I think a lot of people are still in the dark about it, and the government's certainly not in a rush to broadcast it because I think they realize that there's a few hairs on it.
Thank you. Well, what I'm going to do now is a hand over to my moderator, Daryl Budge, my good friend and colleague in Western Australia, and ask him, Daryl, do you have any questions which our viewers have sent into us while we've been talking with Henry today?
Yes, well, I have a question, Henry, that you mentioned that we've got already human rights acts in various state parliament, at state level. And you've pointed out there's existing human rights acts like in Victoria, Queensland, ACT have had minimal positive impact. So what can we deduce from that?
Well, I think if you look at Queensland, Victoria, ACT, they already have existing human rights acts, similar, but some key differences, but similar to what is being proposed at the federal level. They were in place for the pandemic. And those jurisdictions, particularly Victoria, were the worst offenders against human rights over the course of the pandemic. So I think it's not necessarily, a bit like the Soviet Union example or the North Korean example, it's not necessarily what you espouse. It's not just talking the talk, you got to walk the walk. So I think it demonstrates that they're largely ineffective in protecting human rights. My concern is that they're not necessarily just pointless from what they attempt to do, but they're actually quite dangerous on the perverse side in terms of having a negative outcome in terms of it's no protection from the government impinging. It's also pretty ineffective when other citizens try to impinge your human rights as well. So I think they're a good example of how useless they were, and a lot of the witnesses who came before our committee inquiry talked about how the formal processes that people had to appeal were just completely pointless and just completely ignored. So it's human rights is really most important when it's those sort of crisis moments where they're the hardest to defend. That's really when you need the protection of human rights, and as we discovered, they largely didn't mean much. The other aspects that I found concerning, from a Christian perspective, has been the first point in the preamble of what's being proposed is that human rights begin at birth, which hasn't been the international accepted standard. The unborn do have rights, and they're internationally accepted rights. And also there's a really strong focus on how human rights mean, a particularly special, or hold a particularly special place for Indigenous Australians. And I reject that concept. I think that human rights are for all humans, regardless of their race or their background.
Yes. Yeah.
It's just another example of where we're losing track of what makes us all equal, as opposed to using it as sort of an opportunity to pander to, to what's politically correct.
Yeah, you've kind of slid me into the next kind of question. There is an entrenched kind of assumption of cultural rights, as you've been discussing. And in my research, there's a 200-page report by the Human Rights Commission advocating for this act, but also there's a summary report called Free and Equal, a position paper, Human Rights Act for Australia. And that's only 44 pages. So I'd recommend our listeners go and actually read that. It's only 44 pages to listen. And there in that report, they talk about that this act should reflect key rights and principles in the United Nations Declaration on the Rights of Indigenous Peoples. And in that, they explain that they should interpret the whole act in light of that declaration in cases where the rights of First Nations peoples have been affected, and they advocate for the right to self-determination, and they advocate for the operation of a voice to Parliament in their position paper as well. So Human Rights Commission is kind of advocating for that which our voters in Australia have already rejected, in the vast majority. So what's your reaction to that?
Well, I think that they don't seem to be too concerned about what the majority of Australians think. I've noticed with the Human Rights Commission, there was only one Human Rights Commissioner who opposed the voice. And that was Lorraine Finlay, and she's a wonderful contributor to the public debate. But they're not too concerned about what Australians think, and they're not necessarily concerned about what Australian governments think, even though they're the ones that pay their wages. It had been the policy of the coalition government for the previous 9 years before this government to oppose the Human Rights Act. Yet this government entity was pushing that as an advocacy agenda throughout that decade. And even the previous government the Rudd government was opposed to a Human Rights Act, but still they were pushing that agenda. So it concerns me that we've got a large quasi-government entity that's pursuing its own agenda, completely divorced from what Australians think and the Australian taxpayers who are funding them had the view on. So it is concerning. I was watching closely that I think it was last month, they had a conference in Sydney essentially championing their Human Rights Act. And part of that was training on how to sell this act to the Australian people. And I find it a bit disconcerting that we've got an Australian government entity running sort of activist training sessions to try to convince the Australian people that they know what's right and the Australian people don't know what they're talking about, sort of thing. So I just find it quite bizarre. And when you see the sort of people that they assembled at that conference, you really raise an eyebrow about what this all involves, including they had there as one of their key guest speakers was the commissioner from Tasmania that had taken Bishop Porteous to, pulled him before their tribunal to answer for his comments in relation to traditional marriage. And I just think that's, telling as to what they're about and what they're motivated by. What worries me is that they're taxpayer funded and get a huge staff. So we're going to be up against it and opposing it. But that said, I think that Australians are good common sense people who, when they hear the arguments, will make up their own mind.
Another question is, how does the model actually work in regards to civil versus criminal kind of action? And how does it operate on a tribunal level and in the court level? How would it actually operate? What the model they're proposing?
It's a very good question. It's quite complex. Essentially, there is no sort of criminal sanctions or anything like that. What it would essentially do is establish a list of rights, and it would articulate what these rights are. And as I've mentioned, they're sort of selectively devaluing certain rights that we take for granted. And essentially what they say is that the government has to have regard for these factors or these rights when creating legislation or creating policy, and then really opening up the avenue for people to take instances where they feel that a certain legislation or a certain regulation isn't meeting that, take the government through the courts or through a tribunal in the first instance to try to get that rectified. So I don't think it's necessarily going to be of concern to, from an individual perspective. It's more what it means for government policy moving forward. And what will be what people may try to use it for in terms of trying to achieve changes in the approach that governments take.
So who's the authority that this is reported to that decides to bring the complaint and enforce the complaint?
Well, the model that's being proposed is that the Human Rights Commission would become would broaden its role. And of course, you can suddenly understand why they're the ones championing this proposal, because they want to build their own empire and use that as an opportunity to champion this, or to essentially be the first port of call for any complaints. And then beyond that, if they haven't got satisfaction through the AHRC, they would then take it up through courts. So it's, you can imagine how many different things will be referred to the AHRC through this process. There won't be a decision of government that won't be somehow interpreted as something that's a threat to human rights. And we've seen some, if you look at a current example that's obviously very topical, the rise of anti-Semitism. I understand that the Australian Human Rights Commission has effectively done nothing on that front. They took them, I think, 6 or 7 months post October 7 to issue any statement in relation to that issue at all. And there was also revealed that there had been an email coming out from staff members within AHRC saying that the AHRC was being too strongly, or it needs to do more to call out Israel's genocide, etc. So you've got a big army of activists within that organisation. And if I can think of any entity in Australia that I'd least like to have sit in judgment over our human rights, it's actually the Australian Human Rights Commission.
It is very dangerous times, isn't it?
Mm.
I don't remember if you've mentioned this quote earlier, but former Chief Justice Harry Gibbs talked about, if society is tolerant and rational, it doesn't need a Bill of Rights. And if it's not tolerant and rational, no Bill of Rights will preserve it. Is that what you mentioned earlier? I can't remember if you mentioned that quote earlier,
Yes.
but yeah. So in the context of then, why are we handing the commission this kind of power? Because we're not really being tolerant and rational at the highest levels here.
Yes, it's well, exactly right. I think that it goes to what actually shifts the society. What actually, and I think this is an issue that a lot of us grapple with. Does politics flow downstream of society, or is it upstream? I think it's a bit of both, to be honest. But you've got to I think what really makes Australia a great place to live in, and a place that really respects rights, is our underlying culture and our underlying tolerance. And part of that comes from the fact that we've had good, stable systems of government that work and allow people to operate within. And we've had, relative peace, and we've had relative prosperity. But going back to that quote that was raised at the top of the hour, I think that we're also the great inheritors of this Judeo-Christian tradition that has enabled us to treat people equally and have an underlying sort of love within our society. And even those who don't accept our faith, they still are the beneficiaries of that culture anyway. So I think that Harry Gibbs made a really good point there, that you can pass whatever legislation you want, whether it's benign or evil, but it's ultimately it's going to be the Australian culture and the Australian people and the Australian way of doing things that ultimately will be the arbiter as to whether we have good respect for human rights or whether we trample upon human rights. I think that any attempt to firm up fixed legislation, this is how much this is allowed and this is how much that's allowed, I think it's madness, really. You're never going to get to the bottom of it. You're never going to get it right. You're best to just leave it to the open debate and the political system to work it out. It's up for us to say, hey, you're going after religious schools too much, or you're going after people who have a dissenting view on X issue too much. That's a political debate to have. It shouldn't be something that should be locked in firmly within quasi-constitutional legislation.
I just want to flag with our listeners, we have actually done a magazine report on this in our Family Voice news point in May that was put on the bottom on page 3, if you've got a copy of that at home. Otherwise, you can ask our office for a copy. And we're also reporting Henry Pike's views here in our next magazine in August. So if you get a copy of that from our office, if you don't already subscribe, I would really recommend it. So on the front page, Henry goes through the top 5 points of why this bill is not helpful. And also, another question here from Andrew is basically talking about, why are we getting to this point where we prioritize rights based upon kind of a generational conditioning? And I think where he's getting at is with the whole idea of group rights versus individual rights, that we've raised a generation that's going towards thinking about identity politics, group rights. And that's kind of the mentality of the commission that's been raised in this kind of Marxist theory about group rights. Where do you think that flows in reaction to this bill?
Well, it's definitely cementing it in. That's a trend that's occurred over recent years that I think has been quite un-Australian, really. Like, that's not the way that we've traditionally thought about ourselves. Or maybe I'm being unfair there. There was a lot of there was very much perhaps more of a political tribal instinct earlier on in terms of whether people were, Catholics or Protestants. Perhaps there was a bit of that in the start of Australian society, but for the most part, we've been incredibly egalitarian and individualistic, and certainly we don't. It's been the Australian way not to really tolerate anyone who gets, who wants to boss us around too much. And unfortunately, we're getting into this point now where everyone's seems to be getting softer and getting more sensitive and getting more, concerned about the identity that they fit into, or sorry, the group identity that they fit into, or the tribal identity they fit into, as opposed to individual freedom. So I think this will only cement that and make it worse, and put people into boxes, as opposed to actually pushing back against that whole trend, and trying to get people out of that frame of mind and thinking about what makes them, I suppose what motivates them as an individual, and what things mean to them as an individual.
I think those are all the questions I have, Andrew. So we can conclude there.
Yeah, well, thank you for your thoughts there, Henry, and for giving us some light on a situation which has been messy and it hasn't altogether been that clear to the average person who watches the Parliament. And it's helpful to have someone who's been right in there in the trenches, been watching the debates and watching the different points of view. So thank you for sharing that with us, and we trust the rest of the year is a successful one for you and the Parliament.
Thank you very much. Really appreciate it, Andrew, and thank you for everyone for joining us today. And really appreciate your support.